Hello, this afternoon I'm actually with Mr. William Sanchez. He's a real estate attorney in practice for over 20 years. Mr. Sanchez, can you actually share with us some of your background and experience as well?
Okay, well, like you said, my name is William Sanchez. I have an office here in Roselle, New Jersey, and I have been practicing law for a little over 20 years now.
Yes.
Actually, almost in November, it'll be 21 years.
Great.
And in the past 5 or 6 years, I have been concentrating my practice on primarily residential real estate transactions,
Gotcha.
some commercial transactions. I'll do them if they come, but I don't get that much commercial work.
Today I'm basically, like we discussed, there's a lot of information that people are not familiar with when it comes to either sell their property or buying a property. And I think it's very helpful that they can have probably the general information of what are the main topics when it comes to the legal proceedings. One of the many questions that I get from my buyers and as well from sellers is, what is attorney review? How can you give us some detail on that?
All right, well, attorney review is simply in every real estate contract in New Jersey.
Yes.
There is written into it a 3-day period.
Okay.
Okay. From when the offer is accepted.
Perfect.
By the seller. Generally, the way it works is a buyer says, I am willing to pay X amount of money for this property based on the listing or whatever that may be. And then the seller accepts. If the seller accepts, then you have 3 days to terminate that contract for no reason at all. You just simply change your mind.
Yes.
Or to request changes to that contract that you or your attorney may want.
Sounds good.
Okay. Now, one thing to remember is that 3-day period is weekdays. Saturdays, Sundays, and national holidays don't count, okay, in that 3-day period. So if I get a contract, Friday afternoon,
that's right.
Day one is Monday.
Okay.
Okay, so you have Monday,
Tuesday to
Tuesday, Wednesday to respond.
Sounds good.
Generally, I try to respond within 24 hours. If I can't respond within 24 hours, then within 48 hours.
I understand.
And what you have to remember is if I represent the buyer, once I send out my attorney review letter to the seller or the seller's attorney, then the time period stops ticking. The time period is to reject and terminate the contract.
Yes.
Okay? Once the attorney review letter must terminate the contract. But what it normally says is the contract is hereby terminated. However, it can be reinstated if you agree to, any number of things.
That's right.
An attorney review letter could be, 1 paragraph long, or it could be 10 pages long. It all depends. It all depends on the contract. It depends on the attorney. It depends on the buyer. And then the seller can respond. The seller doesn't have to accept your changes. The seller could say, well, I don't accept any of your changes, and the contract is hereby terminated.
And
that can happen too.
Back on the market.
Yes, exactly. So the attorney review period is a period where each party has an opportunity to request changes or terminate the contract without penalty.
Good. Thank you. What is actually the mortgage contingency? How does it work on a contract?
Okay. The vast majority of residential real estate contracts in New Jersey, and I would imagine anywhere else in the United States, have a mortgage contingency clause. Mortgage contingency clause says, well, I don't have the cash to buy this house, or I don't want to use my cash to buy this house.
Yes.
And I am borrowing the money from the bank. And if the bank does not lend me the money, then I don't have to buy the property. Now, the mortgage, that's the basics.
Yes.
Now, mortgage contingency clause could be a lot more detailed, okay? It can specify the type of loan. You could say, well, unless I only have, 5% to put down.
Yes.
So I need an FHA mortgage.
Yes.
So if I can't get approved for an FHA mortgage, you specify that the mortgage is an FHA mortgage. And if you get denied for an FHA mortgage, nobody can say, well, you have to apply for a different mortgage.
Gotcha.
You can, you only have to buy with an FHA mortgage if the mortgage contingency clause says so. You also have to remember too, there's a lot of things kind of built into a mortgage contingency clause that, for example, the bank is typically going to appraise the property. The bank lending you the money for the mortgage
Yes.
is going to want to know how much that house is worth
Of course.
in relation to other properties in the vicinity. So they're going to do an appraisal, and if they don't like what the appraisal says, they don't have to lend you the money.
So that's basically a contingency as well, based on the appraisal, on the value of the property as
basically
well.
a contingency within the contingency.
There you go.
And typically,
Yes.
typically, there isn't anything specific about the appraisal
Okay.
in the mortgage contingency clause itself in the contract,
Uh-huh.
but it's a condition of the bank itself in order to give you the mortgage. So, as long as you're acting in good faith, as long as you do everything that the bank asks you to do
Yes.
in applying for that loan, and then you get denied, then you just declare the contract null and void based on the mortgage contingency clause, and you provide the seller with a copy of the denial letter, and you get your deposit back, and
Move
that's
on
that,
to the
and you
next.
move on.
That's right. What are some of the most common issues that through the contract actually the contract doesn't go through, fails, and the people has to go back into looking for a property, or the seller has to go back and place their property on the market again? What are the most common issues? I know the home inspection often comes as one of them.
Yeah, well, mortgage denial,
Yes,
and then inspection issues.
that's a big one.
You should always get a home inspection. You do a home inspection, a tank sweep, and at least wood destroying insect infestation inspection.
That's right.
Okay? At the very least.
Yes.
What happens is in almost every contract you have an inspection clause.
Yes.
Okay? And if somebody asks you to waive your rights to inspection, say, okay, but I'm not buying this house then. Bye-bye.
Which was very popular in the last couple of years, where people were at some point trying to waive the inspection just for the purpose of getting the property, since the low inventory was a very big issue right here in the U.S.
Well, yes, and I came across a few of those. And
Yes.
what I would do is I would tell people, listen, if you want to waive your rights, I'm not going to represent you.
Yes.
Because if you're waiving your rights, you don't need a lawyer.
That's right.
Save your money.
Makes sense.
I will not represent anybody, a normal person, that is buying a house to live in that waives their inspection rights. I don't care what you tell me.
You don't know what
I don't
actually
want,
they're walking into.
Listen, I don't want any part of that.
That's
I don't
right.
want any part of that.
Well, the important thing is representing your client and the well-being of them in their property.
Listen, I'm not saying other lawyers don't do it. I'm saying
Yes.
this guy you're talking to right now, if you want to waive your inspection rights, go right ahead. But I'm not going to represent you.
Yes.
It's just that simple.
We're talking about basically contingencies, inspections. What are all the reasons that people come out of the contract, or that they should be aware of, so they don't get by surprise in the middle of it and then they end up losing the deal?
Okay, well, a bad inspection report.
Yeah.
Most common issues, a tank,
Yep.
an underground storage tank
Yes.
that is either abandoned or abandoned with permits,
Yes.
which usually means that they filled it with
With
sand,
sand, yes.
or some other substance, whatever
Sand.
they're using nowadays. I'm not sure if they fill them with sand still.
I think with some foam as well. I think
Yeah,
there is something
possibly.
like that as well.
And my position is always that I don't care if that tank was abandoned with permits. That tank has to come out.
Bottom line.
Has to come out.
And I totally agree with you because if I'm a buyer and I'm accepting the property with a tank that is underground, but of course it's been put it's empty, it's filled up with sand, whatever is the case, I'm taking the responsibility that my future buyer might not be willing to accept this tank in those conditions and rather have it removed. As I heard this many times, and I also at the same time I suggest always to have it 100% removed out of the property to avoid any issues in the future.
I agree. The one thing is, it could be properly abandoned, like I said, and they'll give you a permit and all that. It was done properly whenever
Yes.
it was. Could be a year ago, 2 years ago, 5 years ago, 10 years ago. My position is that it has to come out because you never really know for sure if there's contamination or leaking or anything until it comes out.
That's right.
And like you just said, it's entirely possible that despite that having been abandoned properly, whoever you go sell it to in 5, 10, or 15 years is going to want it removed.
Yes.
And then listen, removing a tank, if there's no contamination, isn't that expensive. It's not a big deal. It's actually pretty easy.
Yes.
But if there's a leak,
If
there's a little hole in there somewhere, then you have to test the soil.
That's right.
And if there's any kind of level of contamination, listen, you could have minor contamination that only costs a few $1,000s to clean
That's
up.
right. But you never
But
know.
if you're a regular homeowner, and let's say a cleanup is going to cost you $12,000, $13,000, $14,000, $15,000, that's a lot of money for most people.
Makes sense.
Makes
sense.
So I believe in completely avoiding those risks altogether.
Correct.
That's the most common issue. Number one, the tank. Number two, water penetration. Number three, some sort of asbestos.
Yes.
Okay, mold.
Well,
Number
that's
four,
a big one.
mold. Okay, those four things
Yes.
are the primary reasons why contracts get terminated rightfully. You don't have to buy a house that has asbestos in it. If you confirm that it's asbestos, you can say, I want it removed. If the seller doesn't have to remove it, but you also don't have to buy it. Same thing with water penetration. Same thing with mold.
Yes.
Those are reasons that if you do a home inspection and it's demonstrated and you have a licensed inspector telling you that you have these issues, that if the seller doesn't want to address them,
Yes.
and you have a proper inspections clause in there, you can get out of the contract.
And
Generally speaking, for those reasons, you don't have to buy a house that you know has those kinds of problems.
I understand.
Or a leaky roof is also a problem. A bad roof. Now, if a roof is old, and it looks terrible, but it doesn't leak,
Yes.
that's not necessarily a valid reason to terminate a contract, in my opinion.
Oh, interesting.
Okay?
Okay.
Because technically all purchases except new construction in New Jersey are as is. As is means the seller doesn't have to make any repairs.
Yeah.
So, you should, in the attorney review letter, you might want to put some, language about a roof in there, so.
To avoid any penalties.
Well, to avoid having, let's say you're putting all your money into the house for the down payment.
Yeah.
Any run-of-the-mill roof is going to cost you at least $10,000, probably more now with the way construction materials
Makes
have
sense.
gone up.
Yes.
All right. So those are the primary reasons that deals fall apart,
Good.
in my experience.
Perfect. Attorney review, mortgage contingency, home inspection, under contract, being under contract, and the penalties that you can have removing yourself out of the contract. Now, can we talk about title clearance? What that means and how important this is for either buyer or seller?
It is extremely important for the buyer.
Yes.
If the seller sells you something with bad title, it's bye-bye, he's done and free and clear.
That's right.
Unless there was a material misrepresentation.
Okay.
Okay? Typically, every contract has language in there that the title has to be clear, marketable, and insurable. Okay?
Understood.
You can, I I represented somebody that sold a property that there was a pretty serious title problem, but it wasn't a buildable lot. The guy that was buying it only wanted it to store construction equipment on, so he really didn't care. So he bought it anyway, even though he would never be able to sell it. Okay? But if you're buying a house to live in, and basically that house is part of your retirement plan, and you plan on living there for 25 years and then selling it when you retire, you want clear title.
Clear title.
Okay, what are the most common issues that pop up? And typically I order a title search once I have a mortgage commitment.
So that's the process, having a mortgage commitment first before ordering a title. That's
the way I do it.
Okay.
That's the way I was taught to do it when I first became an attorney. That's the way I still do it.
Yes.
And
I'm sorry. Why is that?
Because in the event that you order a title search, those title searches cost money.
Okay.
Okay? And somebody eats those costs.
Somebody must eat it. Which is the buyer?
Most lawyers have a relationship with a couple of title companies, and you send them enough business. Every once in a while, if something gets terminated, they're not going to charge you for the searches or your client for the searches.
Because of the relationship built in there.
Because of the relationship built with you.
Yes.
They're supposed to charge.
Yes.
They'll send you a bill, but it's kind of understood that you don't have to pay that bill.
Yes.
Okay? But...
And I understand it's a benefit to the buyer who actually, unfortunately, bump into that situation.
But it's not right. If you're not... A mortgage commitment at least tells you, listen, if this buyer does, these things that are listed here, all of these mortgage commitments that you get are conditional. But all the financial conditions have usually been met. These are paperwork conditions. I need updated tax returns. I need updated pay stubs. I need, I'm sure you've seen more mortgage commitments than I've seen. It's usually a laundry list of things, paperwork that needs to be provided before they clear the file to close.
Yes.
Okay? The famous CTC. Okay? Once that's done, then you can close. However, you don't know if this person's gonna even be able to borrow the money until you have a mortgage commitment. So then you're asking the title company and you're asking the surveyor to go out and do work that they might not get paid for.
Yes.
At least with a mortgage commitment, that there's a bank that says I'm going to lend this person the money. So based on that, you can say, okay, I will order the title searches and I will order the survey so that I can be ready because the bank is also going to need clear title in order to clear the file to close. Okay, because it's not just from the legal perspective of a clear and marketable and insurable title is also something that the lender requires, because if they ever need to foreclose on that property, they need to make sure that they don't have any additional title issues that they have to worry about, because they already have to worry about whether their lender in the future will have a judgment entered against them or a tax lien or any of those things that they have to worry about generally. Okay, at least at the inception of the transaction, you want the title to be clear.
Gotcha. Surveys are usually, in some transactions, I see not being requested. In other ones, I see that is request. One of the good practice that I see is that as a seller, from previous transactions, they have the survey and therefore they can actually pass it on to the new owner.
That is if the survey is less than 10 years old.
Okay.
And you've made no changes. You haven't put up a fence. You haven't put in a pool. You haven't put on an addition to the house. Because in order to accept that survey needs to be accompanied by an original survey affidavit of no change. Personally, I prefer a new survey.
Always. It's the best thing to have a
The best practice is get your own survey. Costs between $650 and $750. And if you don't want to spend that kind of money, which is not a lot of money, then really maybe you should reconsider whether you can afford that house. because a survey protects you against a lot of things.
Okay.
Okay, it tells you where your boundary lines are.
Yes.
It tells you where the structure is in relation to boundary lines. It tells you if the next door neighbor's fence is on your property. It tells you if your fence is on your property. It tells you if your sidewalks and driveways are actually within your property lines. If there's a detached garage, it'll tell you if that detached garage is within your property lines. It basically tells you this is your property. This is what's on your property. This is what's within it. And so, listen, sometimes there are minor encroachments.
There we go. Yes. I
A
was gonna
minor
ask you.
encroachment is your fence is on the line. All of a sudden, at the back end of the property, it's half inch off the line. What does that mean? That means that little 2 feet of fence in your backyard is
Belongs to
half
the-
an inch on your neighbor's property. Most of the time, people aren't worried about stuff
That's
like
right.
that.
But there are some situations where
But
there is a
listen.
greater encroachment, and therefore it's something that cannot be overlooked.
Exactly. So there are situations where if you get a survey, it could save you a lot of headaches.
Okay.
And I could, if we had 6 hours, I could go through a list of
lot of
things.
stories that-
I'm
pretty
I
sure.
could go through some more stories, but
Great.
for the purposes of this, I don't think we need to do that.
That's right.
It's just that getting a survey is the better practice.
Another thing that comes into very popular is closing disclosure, and the buyer getting aware of what is the total expense on the closing and the funds that he has to bring to the closing. I understand that it's a 3 days period prior to closing. How is so?
The closing disclosure statement there's 2 of them.
Yes.
There's a seller's closure disclosure statement and there's a buyer's closing disclosure statement.
Okay.
Okay. The buyer's statement is the one that has to be provided 3 days ahead of time.
Okay.
By the lender. And you have to, demonstrate that you've reviewed it by signing off on it.
I understand.
Now, that document sometimes will be a little bit different from the one you sign the day of the closing because certain things might
Might
change.
change in between.
Okay. Now, most of the things can't vary more than 10%
Okay.
from the initial estimate. Other things can't vary at all. So if there's any variance at all whatsoever, they have to go back and do the numbers, and
the
you
numbers,
may
yeah.
not be able to close. So I don't get involved in that. I don't get involved in that. And back in the old days, we used to prepare the closing statement,
Yes.
and it was a totally different document
Yes.
than what we have now. So now, usually, I don't see the closing disclosure statement until the day before the closing, so I can tell my client how much I need in certified funds
Yes.
or in a wire transfer to the title company in order to close. So I don't get too involved in that, but the closing disclosure statement, generally speaking, is all of your expenses
I understand.
as a buyer for the closing outlined. Expense by expense,
Mortgage
to the
fees,
penny, to
taxes,
the penny,
insurance, and so on.
and it tells you there's a line close to the bottom of the first page, cash to close. That's the amount of money that you need in order to close the transaction.
Have you had situations where maybe the buyer didn't budget properly and might end up short at closing?
Yes.
Yep.
I don't want that is not something you like to see because generally that's a hard problem to fix.
What is the best advice in cases like that?
They're all so different, Carlos,
Yes.
that I wouldn't be able to tell you. My best advice is if at the beginning of the transaction,
Yes.
when you do the numbers, the initial numbers, and you think you need $25,000, $40,000 to close if you're putting down a very small down payment. All right? Whatever amount of money you think you may need to close, have at least an extra $10,000 to $15,000.
Which usually we call as a regular, about at least 3%, 3 to 5% towards the cost of the property towards closing.
Well, you got to think too. As a buyer,
Yes.
your closing costs on top of your down payment are going to be $8,000 to $12,000 usually.
Yes.
Usually, depending on the loan, depending on a lot of things. So, if you're putting down a $25,000 down payment and you have $5,000 in good faith, so that good faith money that's being held,
Yes.
that's part of your down payment. All right. Let's say you have another $20,000 that you're going to bring to the closing as a down payment, and you think your closing costs are going to be $10,000. I would suggest that you have at least $15,000 allocated for your closing costs to account for the potential changes
Yes.
from the day your offer is accepted to the day you close, which is usually between 45 and 60 days.
I understood. This is one of my last questions. What actually happens at closing? I see buyers signing a lot of documents. Sellers also going to. What actually is that they're actually doing right there at that moment?
Okay. The day of the closing, okay, you're going to sign the final disclosure statement, the final
Yeah.
closing disclosure statement, okay? You're going to sign the note, the mortgage, and a whole bunch of other documents that the lender requires. Depending on the type of loan, you're going to have more documents, less documents. Depending on the bank, you're going to have more documents, less documents.
Okay.
All right, you can have anything from a very simple, 50, 60 page package
Yes.
to 200 pages,
Wow.
depending on the lender. Okay? What you're signing there is the note. Importantly, the note is the document that says, I owe this amount of money at this interest rate payable over this period of time. Okay? The mortgage is the document that says, if you don't pay what you owe under the note, the mortgage gives the lender the right to foreclose your interest and everybody else's interest in that property, take it back,
Yes.
sell it in order to recover the money that you owe if you don't pay it the way you agreed to pay it on the note.
Very important.
So, all you're doing at the day of the closing, all you're doing is basically finalizing the transaction. By the time you get to the closing table, you usually have no right to walk away from the transaction. All right? Unless you show up at the walkthrough and, they turn the backyard into a junkyard, between the day of the inspection and now when you went to see it,
Yes.
You might not have to close if the property is full of junk.
That's a
okay?
very important.
All right, but
Other
that
than
doesn't really
you are
happen.
in a
Listen,
responsibility to close.
We can talk about that in a minute if you want.
Yeah.
But at the closing, what happens is the signing of all of the documents that are required by the lender,
Yes.
by the title company, and by anybody else involved in the transaction that may have something that requires signing.
Interesting. Very good.
Okay.
This is very helpful. I often get these type of questions from my clients, whether buying or selling. And one of the things that I look always is give them a guidelines to be prepared. And of course, always reach out to your attorney that can give you the proper advices based on your situation as well.
Yeah. Now, if you want, you said what happens at the closing.
Yes.
Also important is what happens immediately before the closing. You as a realtor, you're going to take your client to the property
Yes.
as
The
close in proximity to
The closing.
as possible.
Yes.
Either the night before, preferably the morning of the closing.
That's right.
So if you're going to close at 10 o'clock in the morning, do the walkthrough at 8 o'clock in the morning. Right?
Yes.
Why do I say that? Because you never know what can happen. The walkthrough is basically to make sure that the sellers aren't leaving anything inappropriate at the property, inappropriate could be anything from, an old couch to 5 junk cars in the back, whatever it may be.
Yes.
Okay? You don't know what can happen between the time you inspected the property, they agreed to do, X, Y, and Z,
Yes.
and the day of the closing. All right? So the walkthrough is basically to make sure that nothing bad has happened. The place hasn't burned down. You know what I mean?
Yes.
There, I don't know. Could be anything.
That's right.
Could be
that
anything.
can actually prevent from closing.
Okay? And if there is a legitimate issue, you could either put off the closing until it's resolved or hold some of the seller's money in escrow, enough money that would cover a professional to come and take care of the situation if the seller doesn't do it within an agreed upon period of time.
I understand. Yes.
Okay, that's fairly common. Those things happen, and it's also common for it to be resolved right there on the spot.
Very good. Thank you, Mr. Sanchez. This has been grateful information.
Okay.
Very good information, and I look forward for continue working with you.
Okay,
Thanks.
let me know. Be happy to answer any questions you have.
Sounds good. Thank you.
Thank you.